My name is Peter Keller. I'm a certified financial planner with Pure Financial Advisors, and welcome to Question of the Week. This week's question is, how do I take title to my account? And an account can be your bank account, your brokerage account, or your home. All right, so there are a lot of different ways that you can take title to your assets, and each one has a different implication both during lifetime and at death. And so each one is critically important to understand how they're handled. So for an individual, you can have sole ownership of an asset where it's titled in your name alone, okay? Now, at death, once you pass away, that is handled through your estate plan via a trust or a will at death. Now, the second manner that you could hold title is tenants in common. And tenants in common is where two or more people get together and they have an unequal interest in some property, bank account, real estate, any kind of an asset. Now with tenants in common, I like to think of it like a book. When you open up a book, there's a lot of different pages, but if you open up the book to whatever the divided interest is, if you tear it in half, then your ownership will go according to your estate plan at death. Now there can be some implications with that because at death, because it follows your estate plan, you may or may not, for the surviving owners, want to sell that property, and you could have a loss of control issue or a fire sale, an occurrence that wouldn't otherwise be desirable. So tenants in common is another form of holding title. Then you also have joint tenants with rights of survivorship. Joint tenants with rights of survivorship is when a married couple or two or more parties together at the same time take possession of an asset and they have 100% or an equal use of that property. Now, when one person passes away, then the survivors, without going through the probate process, continue to take title of that real estate, that property, that asset. Now, with joint tenancy, after the last person passes away, then it's a sole interest and it goes according to the terms of their estate plan, either passing by will or trust. Another form of titling is community property, and that's available only in the community property states. We have 9 community property states. So a husband and wife can own title to property as community property. The benefit of holding title as community property is that when one spouse passes away, the asset gets a 100% step up in the tax basis. So as an example, if you own a stock as a married couple that has a basis of $100,000 and it grows in value to $500,000 and one spouse passes away, then the full $500,000 gets stepped up to the fair market value and the surviving spouse could sell that without paying any capital gains tax. So there's a tremendous benefit to individuals, married couples who live in a community property state to hold title as community property. Now, the last form of ownership that I want to talk about today is holding title in the name of a revocable trust. Now, the benefit of holding title in a revocable trust is that you retain control while you're alive, and when you pass away, it avoids the entire probate process. So there's no time delays, court costs, attorney fees, or public records. Now, a lot of people thought, well, hey, if I don't have $600,000, I don't need a trust. That is an old myth. So that $600,000, that was tied to a unified credit that has since gone away. It makes sense in the state of California to put a trust together when you own either $10,000 worth of real estate or $150,000 of personal assets. So let me explain real quick how a trust works. You first create the legal documents, and it's a 2-part process. The first part, creating the documents, legally, a married couple would be called grantors, trustors, or settlors. depending on the attorney who's drafting this document, they all mean the same thing. So the people who create the document, they are the ors. If you think of this like a bushel basket, you also do all the day-to-day decision-making with the trust, and this person is called the trustee. Now, if something should happen to one of you, Alzheimer's, closed head injury, some form of loss of control, anything that's inside the trust, the surviving or well spouse has full control over the assets. There is no loss of control. Unlike with joint tenancy, you could have a loss of control issue if the well spouse becomes sick, Alzheimer's, old age. There would be a living probate called a conservatorship for the wife to take care of the husband with assets inside the trust. So an example would be if a spouse gets into a closed head injury, an automobile accident, has a closed head injury, and now the wife needs to refinance the house, widen doors so that a wheelchair can get in or make it handicap accessible, then she would first have to go through a living probate, a conservatorship, in order to sign his name for him. Now, if something should happen to both, where both are incapacitated, you name somebody that you trust as a successor trustee. This person's responsibility as a fiduciary to look out for the best interests of the grantors. After both of these individuals are gone, it's this person's responsibility to distribute to children, churches, charities in the manner that is specified inside the trust. So once the trust document is created, the second step is to take the things that you own, like real estate, accounts held outside of retirement plans, tangible property. All of this gets retitled into the name of the trust. So you as an individual, you don't own anything. Your trust owns everything, but you created the trust, which means you can make changes to the trust, and you make all the day-to-day decisions regarding the trust. So how you take title is very important, and especially at death. I am Peter Keller, and that was Pure Financial Question of the Week.